Thanks so much for joining us. I'm Robin. Um, yeah, and I am going to turn it over to Sarah to get us started.
Thanks, Robin. I'm going to share my screen, and hopefully everyone is seeing this beginning of the presentation that says understanding and enforcing housing and fair housing protections, and everyone can hear me. So I do have the closed captions on. I think that's as much as I can do. But if you can't hear me or don't can't access this, please let Robin know, and Robin will let me know. Um, so my name is Sarah Andrew. I'm one of the managing attorneys in the Bethlehem office of North Penn Legal Services. North Penn Legal Services is a civil legal aid organization. We service 20 counties in Northeast Pennsylvania, and the Bethlehem office is sort of the southernmost county. And what we provide is free civil legal representation or advice to people who qualify based on their incomes. And generally, our income qualifications are that you have to be under 200% of the federal poverty guideline. Um, so that comes to about $31,000 a year. So that would, being at or under that would generally qualify someone to um, receive our services. Uh, on this screen is our two QR codes that you can use your phone to access in Spanish and in English. Our tenant rights handbook. This is available on our website. I think this QR code just maybe takes you to our website. A lot of the stuff I'm going to talk about today, it's all about tenants' rights. I'm going to touch on fair housing, and all of this information is in that handbook. It's a lot of information, but it's pretty comprehensive. So you can also just look on our website, npls.org. I think it might be nplspa.org. And in addition to housing work, we also handle other types of legal problems. We do some family law, including representing people who are have filed a protection from abuse. We do Social Security, disability appeals. We do public benefits work in general, so Medicaid, SNAP, um, things of that nature. Uh, we also do access to employment. So that would include criminal eviction expungements or sealings or pardons. Um, we also do name changes if it will help people to obtain employment. It's a pretty broad category that we could help with that. Mm, I'm sure I'm forgetting something, but we do a lot of stuff, a lot of different stuff. What I primarily do is housing work. I represent tenants facing eviction, homeowners facing foreclosure or tax sale of their properties. And so what we're going to be talking about today is tenants' rights for people who are renting, including some fair housing rights under state, federal, and local law. So move this little bar away. All right, so I'm going to start with landlord-tenant law in general. The landlord-tenant relationship is based on a contract, and that contract is called a lease. A lease does not have to be in writing. It can be a verbal lease. So if someone is living in a unit and they are paying the owner of that unit for the right to be able to live there, they don't need to have a written lease to make that be a lease relationship. The law in Pennsylvania that covers evictions is the Landlord Tenant Act of 1951. And contained in that law are the obligations of landlords and the rights of tenants, including the entire eviction process. So that's the law that dictates how evictions happen. It does not apply generally to rooming houses, and it does not apply to hotels, um, unless there are certain circumstances. So if a person is living in an extended stay hotel or motel, or just renting a room in a house, the Landlord Tenant Act may or may not apply. Something else I'm going to talk about through this presentation is the warranty of habitability, which means it's the concept that the landlord or property owner has to guarantee that the place they are renting is safe, and quality housing, that meets minimum standards. The law that dictates how that works is established through case law. It's not in a statute that the legislature wrote. But there are standards related to that. So we are going to talk about housing conditions a little bit. One incredibly important concept here is that a landlord cannot lock a tenant out or make a unit unlivable to force a tenant out. That is not legal unless and until they go to court. The landlord has to follow a legal process. The court that these types of cases start at is the local magisterial district courts, the MDJs. So when I say MDJ or district court, I'm talking about the lower courts in Pennsylvania. For whatever reason, they are frequently found in strip malls. It's the same place you go to contest a traffic ticket. That is where eviction court begins. And until a landlord gets an order from that court, they cannot simply lock someone out. So it has to be a legal process. From the time of the court date, a tenant has a minimum of 21 days before the constable can come and change the locks on them. So a lot of people, especially recently, because people have, especially, non-white individuals or people whose legal status in the United States is maybe not as clear, have reason to fear going to court, and that is fully understandable because if ICE knows that you're scheduled to show up, they can be there waiting for you. So I'm going to say it is very important to go to court. You will always lose if you do not go. But I understand that there are reasons that might keep people from feeling safe attending court. And there's not a whole lot that we can really do about that right now as legal advocates. But I'm hoping that, if we start to see that happening more and more. I know there have been reports of ICE showing up at Lehigh County Courthouse. I'm sure the other county courthouses have seen similar things, and the court system cannot or will not do anything to prevent that because they have no legal basis to keep them out of the courthouse. So all of this is just a kind of a disclaimer, that if you feel safe doing so, you should always go to court, because if you don't go, you're going to lose. Even if you don't show up, if you are a tenant and you lose the eviction hearing, it doesn't mean that that very same day you have to be out. It means that a process has started, and there are at least 21 days between that date of court and the date when the constable comes to change the locks. So that's important to know. Sometimes people just kind of give up. They say, oh, I got evicted because they got an order from court that says they have to show up to court. But really, that process is just beginning there. And if a tenant shows up at court and they lose their case, they have the option to appeal the decision. And the tenant might be completely in the wrong, meaning maybe they haven't paid their rent because they lost their job and they don't have the money. And that's the only reason why they're being evicted, because they haven't paid their rent. That's not really a legally meritorious reason to not pay rent, but that doesn't matter. They can still appeal that decision to the Court of Common Pleas, and this will give them more time to move. So we're going to delve into this a little bit. These are sort of the general concepts that I want people to understand moving forward. So let's talk about, go to the next slide. Okay, the stages of the eviction process. So it usually starts with what we call a notice to quit. A notice to quit is a letter from the landlord to the tenant that says, you need to be out by such and such a date for such and such a reason, or else, eviction actions will be taken against you. If there is a written lease, the notice to quit can be waived in that lease. So there can be a section in the lease that says, I, the tenant, waive any notices. That section in the lease is supposed to be really obvious and clear. It's not supposed to be buried. A person is supposed to know that they're giving up a right when they sign a contract. But more often than not, if there's something in the lease that says notice can be waived, the judge may find that notice was waived. So usually this process has to start with a notice from the landlord, but not always if it's waived in the lease. If it's an oral lease, then the notice to quit cannot be waived. And this process must start with a letter from the landlord. Now, this is something that should be in writing. If the landlord texts someone or communicates to them in a portal of some kind, we always argue that that's not sufficient. It should be something in writing that is mailed to the tenant. And the time periods for the notice to quit depend on what the reason is for the notice to quit. So if the reason for the notice to quit is non-payment of rent, then the landlord has to say, you have 10 days to pay this rent, or I'm going to file eviction against you. If it's a breach of the lease, some other kind of breach of the lease, like a noise violation, or you have a dog and you're not supposed to have a dog, that's a 15-day notice. And if it is end of lease term, like if you're at the last month of your lease and your landlord simply does not want to renew that lease, then the notice period should be generally 30 days, is what we look for there. So that's just sort of a general rule of thumb. And what happens is if that notice period ends and the tenant is still there, they haven't moved out, only after that period has ended can the landlord file the complaint in court. So if you're a tenant and you end up in eviction court and your landlord gave you a notice on July 1st and then filed the eviction case on July 2nd, then that case should not be heard because it was filed too soon. That case should be dismissed because the landlord has to give you time to comply with that notice to quit by either paying the rent or stopping the breach or moving out. So that is one defense that comes up a lot, is premature filing. Once the landlord files in court, the hearing gets scheduled for 7 to 10 days later. Then the tenant receives the complaint and notice of hearing from the court, that tells them, when to show up. A tenant can file a cross complaint if they have, beef with their landlord for some reason, like if repairs were not made that were promised, or if their landlord has wronged them in some kind of way, like refusing to accept payment or something like that. The tenant can file a cross complaint, and then both of those cases will be heard at the same time: the landlord's case against the tenant and the tenant's case against the landlord. So say a pipe burst and your basement flooded and a bunch of your stuff got ruined. You can file a cross complaint for the damages. I will say too, if you are a tenant and you do not have renter's insurance, it is very affordable, and I really recommend that you get it. I mean, some of the policies are like $6 a month, and if something like that should happen and your property is destroyed, that is basically the one way that you might get any compensation for it, just realistically. So I'm a proponent of renter's insurance. All right. And then the next step is that the tenant attends the hearing, the landlord attends the hearing, and the judge has 3 days to issue a judgment. So that's the beginning stages of starting the process. Um, there are a couple different things that can happen at the hearing. One is that the tenant can win, and the case is either dismissed or found in favor of the defendant. The tenant is the defendant in these cases. So that's a possibility, and that happens sometimes. It's kind of rare in our experience, but it can happen. More likely, if we can't fight our way through it, the types of judgments against the tenant would be possession granted to the landlord or possession granted if money judgment is not satisfied, which I'm going to call a pay and stay throughout this. So it's either possession granted, like outright, or a pay and stay. So the tenant, if possession is granted, the tenant has to move out by the eviction date unless they file an appeal within 10 days because there's no other way through this. You have to file an appeal within 10 days after the hearing, or else on the 11th day, the landlord goes back to court and gets an order for possession. And then there's another 10 days that the constable will give before the constable will come to change the locks. So that's why I say 21 days from the date of the court hearing. So if you don't do anything and it's straight possession granted, then you're likely going to be out 21 days later. You have 10 days to file an appeal. If it's a pay and stay, then the tenant has the opportunity to pay the judgment amount and avoid the eviction. They don't have to appeal. But if there's some doubt about being able to pay that full judgment within 10 days, then we always recommend the appeal. Let's see, Robin, can you remind me how long my part of this is?
It should be about 45 minutes.
So like 7:15.
I think it would be, so we started at 6:30, so it would be like, yeah,
Yeah.
7:15.
Okay, cool.
Okay.
Great. Awesome. Thank you. Thank you. All right. So if it's possession granted, you have to appeal or you have to get out. I kind of talked about some of this already, but there is this concept when you file an appeal, that appeal gets filed in the Court of Common Pleas for the county where you live. So if you're in Lehigh County, that's Lehigh County Court of Common Pleas on Hamilton Boulevard in Allentown. If you're in Northampton County, it is Northampton County Court of Common Pleas on, I think, gosh, I forget the name of the street, but it's over in Easton. So Washington Street, I think. I should really know that, but I apologize. So that's where you file the appeal. And a tenant must basically pay a bond to the court in order to retain the right to stay in the property while waiting for the appeal hearing to be heard. We call that a supersedious. When I say supersedious, that's what I mean, that you have to pay that bond, which is the amount of your rent, into the court every 30 days from the day that you file the appeal. So you have to walk into court with the amount of the rent, and there's rules around how much you have to pay, and it's going to change based on what your income is. If you're lower income, you might be able to get the filing fees waived, but the general concept here is you pay your rent into the Court of Common Pleas in order to continue to have the right to stay in the property until there is a hearing. And so I think I talked about this other stuff here. If the tenant doesn't vacate by the eviction date, then the constable will forcibly evict the tenant. So what does that mean? Generally, the constable will just come with the landlord or a representative from the landlord and change the locks. The only time they're gonna have to use any kind of force or anything like that is if there is like a physical altercation of some kind. They can physically remove people, but for the most part that doesn't happen. They just sort of they stand there while the landlord changes the locks, and then the tenant can't get access to the property anymore. They do not take all of your stuff and throw it out onto the street. There are rules around how to get your stuff back. That does happen some places, but in Pennsylvania they just change the locks. If it's a pay and stay, the tenant can pay the full judgment to avoid the eviction up until the second the constable is standing at the door. Um, but there might be some additional fees if it gets to that point, because it costs the landlord a little bit to arrange for the constable to come out. And if that's the route that someone is going to go, then you should be prepared to pay in cash, because they're not going to take a check at the door when the constable is there. If you get a pay and stay, you can still appeal, but that means you kind of don't have the pay and stay anymore. Um, and so that's the same rules apply with how the constable thing works. I'm wondering if I need to talk any more about any of that. That's sort of like the eviction process. And just to talk a little bit about what the appeal situation looks like. Basically, the tenant files the appeal. They have to send notice to both the landlord and the magisterial district judge that they have filed the appeal. They have to pay their rent, their supersedious, into the court every 30 days. If they don't pay that supersedious into the court, then on that 31st day, the landlord can terminate the supersedious and get an order for possession. So you really have to keep up with those payments to the court. And then the timeline of all this depends on what court you're in. But generally in Lehigh County, they schedule the case for arbitration. And that's maybe like 3 months out, 2 or 3 months out from the day that you file the appeal. In Northampton County, the parties kind of have to force the issue a little bit by scheduling it for arbitration or for a trial. And the next thing that happens after the tenant files the appeal is that the landlord has to file a complaint, and then the tenant has to respond to the complaint. And then there's ultimately a decision by a judge. So that's like what the appeal process looks like. For a lot of people, the purpose of appealing is just to get more than 21 days to figure out what their next move is going to be. But people might have a good legal reason that they should not have the eviction judgment against them. So we do win cases sometimes. I'm going to talk a little bit about the warranty of habitability and how to deal with poor conditions at the property. So I said before, this isn't written into a statute. It's implied by law in every residential lease in Pennsylvania because of this case called Pugh v. Holmes from 1979. And what that case says is a landlord has an obligation to provide safe and sanitary conditions, which includes working heat, working utilities, no insects, no rodents. A landlord can't rent a clearly uninhabitable apartment and say, hey, well, it was like that when you moved in there. The landlord always has the obligation to provide a habitable place. Now, I will admit, while tenants do have some options here for how to deal with it when they are living with poor conditions, they're not great options. And sometimes people are tempted to call codes thinking that they will solve their problem. But if the place is too uninhabitable, a municipal codes department might tag the property as uninhabitable, meaning you have to move out like right away. So it's worth maybe talking to one of our advocates if you're thinking about calling codes, just to kind of weigh the pros and cons of that. Because, if the problem is you don't have any hot water or any running water, or there's sewage in the basement, yes, those are terrible things. You shouldn't have to live there. Codes is going to come out if you call them, and they will say, well, you can't be here. So it makes your problems worse sometimes. The process that you should use for requesting repairs is to document. Contact the landlord and give them a chance to make the repairs. Do it in writing and keep a record of the request you made. Text messages back and forth could be admissible in court. A dated paper letter, even better. I would love to see that. The timeline for the repairs is just based on reasonableness standards, depending on what the problem is. like how severe it is. If the landlord doesn't respond, then notify in writing of the problem again and say, I'm going to fix this myself if landlord, if you don't come fix this. So that is called a repair and deduct type of a plan where the tenant can say, hey, um, my water bill is crazy high because this toilet is running constantly. A plumber needs to come out here. Um, the landlord does nothing. The tenant says, if you don't get a plumber out here by the end of this week, I'm going to get a plumber and deduct the cost of that plumber from my rent. And if the landlord still doesn't do anything, then the tenant is within their right to bring a plumber in to do the repair and deduct the cost of that from their rent. The problem with that is that if you pay reduced rent, you're basically buying yourself a ticket to eviction court. And that's why documenting this is so important because you have to show that you acted reasonably. And if the cost of the repair is more than what your monthly rent is, then repair and deduct is not an option because you can't deduct more than 1 month of rent in a month. So again, if it's a serious problem, you can call code enforcement, but that might go sideways for you. Documentation is incredibly important. Um, the options being repair and deduct, which is like a guaranteed trip to eviction court. Simply withholding the rent without taking those steps earlier guarantees you a trip to eviction court and the likelihood that you're not going to win at the MDJ level. The landlord can't fix what they don't know about. Another option is to break the lease and move out. Just say like, these conditions are inappropriate. I'm not staying here. I'm leaving. Again, documentation of that conversation is important. And then you could also sue the landlord for back rent and other expenses related to the problem because they have failed in their obligations. So you can file a complaint at the MDJ, or that this is frequently a defense in eviction cases. Just always notify the landlord in writing of your plan because you're going to have to prove that you let them know. So, you know, it's these aren't great options because you're going to basically you're guaranteed either facing eviction court, having to move, find somewhere else to live. We all know how much of a problem that is right now, or suing the landlord and maybe you'll see money someday. So, but still, you do have rights. So I wanted to talk about that. That's that. What happens to property left in the home? There's like two more things I want to talk about with landlord tenant stuff, and then I'm going to touch on fair housing for the last couple minutes. So I'm going to talk about property left in the home and security deposits, and then I'm going to move to fair housing. The constable comes and changes the locks. The landlord changes the locks. All your stuff is in the property still. What happens to your stuff? First of all, we always recommend that if someone knows they're facing the situation, like the lockout is happening and there's no way to stop it, have a go bag, medication, family heirlooms, kid stuff, pet stuff, clothing, any ID, anything of super value, anything you're not going to be able to live without, have it ready to go. You're not going to get a lot of time on that day. The constable might give you 10 minutes to grab things, but it's important to just have that really important stuff ready to just go with it. The landlord has to hold everything safe for 10 days after the tenant vacates. They can't walk in that day and start throwing stuff out the window. They have to hold it there for 10 days. Within those 10 days, the tenant has to give written notice that the property is not abandoned and give a forwarding address and say, I want to make arrangements to come and get my stuff. The landlord cannot hold the property hostage. They can't say, yeah, you can get your stuff if you pay me. The landlord has to allow within those 10 days time for the tenant to come get access to remove their belongings. And if the tenant gives that notice that they have not abandoned their things, the landlord has to keep that stuff safe for at least 30 days. But they can charge storage fees after 10 days. So they could take it out and put it into a storage unit. And then you have to pay the storage unit fee to get your stuff back. So you basically have 10 days to make those arrangements. The landlord is supposed to comply so that you can come with the U-Haul or whatever and get your stuff out. If the landlord doesn't listen to this stuff. If they do get rid of your things, you have the option to file a case with the either in the Court of Common Pleas or with the magistrate to, that they have deprived you of the value of your property. Magisterial district court cases are, it's like small claims court. So it's a $12,000 limit on those cases. So if the value of your stuff is at or under $12,000, you can file it at the MDJ. If it's over, you have to file it at the Court of Common Pleas, which is a little more expensive and more involved. But that is an option. And now security deposits, another important thing. Many people kind of assume that they can have their security deposit take care of their last month of rent. That is not accurate. That can be arranged if your landlord wants to do that with you. But the purpose of the security deposit is to safeguard against damage the tenant might cause. So if the tenant leaves and they return the keys, they have to give the landlord written notice of where to send their security deposit. This should be a letter. This shouldn't be a text message. This should be even just a piece of paper that says, I'm gone. I want my security deposit back. You can send it to this address. It doesn't have to be your forwarding address. It could be a friend's house. It could be a P.O. box. If you don't want, if you have bad blood with the landlord and you don't want them to know where you are, but you have to give a forwarding address. Once you do that, it sort of triggers the next phase of things. If you don't do that within 30 days of leaving the property, your rights are a lot more limited. So if you want your security deposit back, ask for it in writing within 30 days of moving out. Then once you ask for it in writing, the landlord has 30 days to either return the full security deposit or give you an itemized list of the damages they took out of it. Like this thing was broken, $200. This thing was broken, $150. You can dispute these damages in the magisterial district court. But if the landlord doesn't send you anything at all, either a letter with an itemized list or your security deposit, then the landlord loses the right to keep the deposit for the damages, and you can sue them for double the amount of the security deposit. These rights cannot be waived in the lease. But and people have been successful suing their former landlord for the return of their security deposit. The hard part, though, is collecting on that judgment, because once you get a judgment from the lower court and then you certify it to the Court of Common Pleas, and then you have to go through like collections procedures to try to get that money out of the landlord. And that's where people, it's like you may or may not ever see that money. You could actually put a lien on the property. There's things you could do, but it's difficult and it's a lot of runaround. So while tenants do have rights under these circumstances, this situation here does see a lot of abuse by unscrupulous landlords. But the process to begin is to give them the notice you want it back and a forwarding address. That sort of concludes what I wanted to talk about with tenants' rights and the eviction process. And when we get to the end and we are going through questions, I'll answer whatever questions aren't like super specific to someone. If you have questions about your situation, then better to call me later and we'll go through it in a non-public forum. I forgot to give my little disclaimer in the beginning that none of this is legal advice. I'm just providing information. So y'all aren't my clients. I'm not your lawyer, but this is information for you to use. So my last couple minutes here, I want to talk a little bit about fair housing rights. So fair housing rights, I'm going to speed through these slides a little bit. Fair housing rights come to us from federal law under the Fair Housing Act. It's part of the Civil Rights Act of 1968. We also have state level fair housing laws and county and municipality level laws. In general, what we're talking about here are laws that protect individuals in certain protected classes from discrimination in housing transactions. And the laws apply to dwellings. And that might include like where land is offered for sale, where a dwelling will be built. It's a very broad term, but those are sort of the two factors, being in a protected class, and it applies to a dwelling. So the big questions: who's protected, where are they protected, what sort of behavior is prohibited, and are we dealing with discrimination here? The protected classes under federal law are these: race, color, national origin, religion. In 1974, the law was amended to include sex. In 1988, it was amended to include familial status and disability. The sex discrimination section of this has been sort of expanded over the years and retracted over the years, depending on who is in charge of the government. So we're not doing great right now as far as this goes at the federal level, I'll be honest. I think no one is surprised to hear that. Um, but that it is, a class. Dwellings, big takeaway here: almost everything is a dwelling. Dorms, uh, uh, manufactured home communities, rooming houses. Fair housing law does apply to hotels, rooming houses, things like that. Homeless shelters on a case by case basis, depending on if it's like a place that you were expected to be able to return to. Most places are dwellings. The exceptions from being a dwelling are sort of few. It's like if it's 4 or fewer units and an owner lives in one of them, then it's an exemption. There's a couple exemptions. For the most part, a place where you live is a dwelling. The more important thing: what is prohibited? The types of actions in the housing context that can't be taken against members of a protected class are refusing to rent or sell housing. I know Rob's going to touch on this stuff later. Refusing to negotiate or having other terms, additional terms in the negotiation or different terms. Advertising in a discriminatory way, like by stating a preference, you know, uh, great for retirees, unless we're talking about like a 55 and over community. That's discriminatory on its face. Things of that nature. No kids, clearly discrimination based on family status. Also threatening or intimidating anyone who is going to or suggests that they're going to exercise a fair housing right. Retaliating against them is also prohibited. Um, the laws and regulations, like I said, federal, state, local. Uh, Looking at time, I think just basically know there's the Fair Housing Act. For properties that are governed by HUD, there's an equal access rule. There's Section 504 of the Rehabilitation Act, and there's executive orders. Everything at the federal level right now is basically, in a lot of ways, is sort of ground to a halt. Where there was protection for people based on their gender identity, an executive order by our current president took that away under federal law. The equal access rule was, reduced to not include gender identity. That's just kind of the world we live in right now. So when we get to talking about enforcement, you can file a complaint with HUD if you feel you've been discriminated against on that basis, for your gender presentation or your sexuality presentation or perceived presentation. But they're not going to do much with your HUD complaints right now. So what we would direct you to do is to seek recourse at the state and local level. The Pennsylvania Human Relations Act does include protections based on gender identity, sexual orientation. And at the local level, things are a little in flux in Allentown right now because the Human Relations Ordinance was just improved and made more clear, but there's not an active human relations commission right now because of the change in the law. I expect that will be handled in relatively short order, but it's sort of on pause in Allentown right now. But in Bethlehem and Easton, there are human relations ordinances, and Lehigh County recently also passed a human relations ordinance that does include sexual orientation, gender identity, and presentation. So let's see. Oh, for some reason I have, see how cute that is? I disappeared all of these because they're not effective right now. Sorry to say. The Pennsylvania Human Relations Act, though, does have some extra stuff above and beyond the federal law. It protects tenants who are associated with individuals with disabilities. It does give guidance on sex discrimination to include the stuff I was talking about. And in Bethlehem and Easton right now, it's explicit. So you do have complaint. I'm going to just talk real quick about the things that you think might be discrimination or discrimination. You know, it's sort of like, you know, when you see it, if you feel you're being discriminated against, you can file a complaint for enforcement. Survivors of domestic violence do have a couple extra rights as a protected class under sex, gender, um, and sexual harassment rules. In eviction cases, if someone has experienced domestic violence, and the reason for the eviction doesn't have to be because of the DV, but if they are someone who has experienced DV in, you know, the recent time period, then instead of a 10-day deadline to appeal the judgment, you have a 30-day deadline to appeal the judgment. You have to go through some stuff. You have to fill out a form. You have to give it to the magistrate and then get that extra 30 days. There's an affidavit that says you're someone who experienced domestic violence, and so you get this extra time. So there's also protections in HUD-related properties like public housing or you know, other places that are might even have received HUD funding for their mortgage or something like that, that protect people from being evicted because they have because of the situation. Like if things have been loud, if the cops have come too many times, DV people who experience DV are protected. I wanted to touch a little bit on the protected class of people with disabilities, because people with disabilities have the extra protection and right to ask for reasonable accommodations or modifications. You're going to get these slides. All this is going to be in there. It's on our website, and you can call me, and I'm happy to talk to you about it. But what that looks like is you can ask for a change or exception to a rule or a policy if it's the reason is based on a disability that you have. You can request it at any time. This comes up very frequently in situations where in our client base, some people have mental health issues that lead to disturbing behaviors. If they're facing eviction because of their behaviors, they can ask for a reasonable accommodation to not be evicted while they seek treatment to address their behaviors. And the landlord should allow that and not proceed but with requesting the eviction. And if they still proceed, then that's when you can file a HUD or a state or local complaint. There's ways to ask for it. This stuff you're going to look at. If the accommodation is expensive, who has to pay for it? Basically, if it's public housing or HUD funded housing, or anywhere, like accommodations are generally not expensive. It's a change in a policy, pretty much cost free. If it's a modification, like I need you to build a ramp, I need you to put in grab bars. If it's HUD funded property, if it's federally funded property, public housing, things of that nature, then the housing provider has to pay for it. But if you're in private housing, if you have a housing choice voucher, a Section 8 voucher, you might be on your own to have to pay for it. But the landlord has to allow you to do it. The landlord, unless there's an undue financial and administrative burden on the housing provider, then the landlord has to grant the request. I already talked about how fair housing laws are enforced by filing a complaint. You can ask for all these things, damages, compensatory damages, punitive damages. I have followed complaints through and gotten settlements for people. So, you know, there is a whole process for this at the state level still and at the local levels. You can file a HUD complaint and a complaint at the state level at the same time. They're not like linked together. So at this point, I think we would encourage that people do that. Just file them both and see who responds first. This is the way that you can get to, HUD or the PHRC. The Housing Equality Center is a wonderful resource. They have a lot of information on their website about how and when to make a complaint, what sort of, things constitute discrimination. Um, you can check their website out. There's a link to that at the bottom. And I successfully got through 716. My apologies, I'm a minute late. But this is our contact information. You're going to get these slides. I think if you call the Bethlehem office number, that 317-8757, ask for me. I'd be happy to talk to you and answer any questions after tonight. So thank you. And I think we're going to kick it back to Robin.
Hi, hello. Thank you so much for that marathon of information. I appreciate it a lot. I am thinking that maybe we'll let folks answer some of the few questions around tenant rights, just so then we can really focus on what Rob is saying on the next presentation. So I think that we have two from what I can see. So we have um, Leah says, I move out from my apartment fairly soon. As I understand it, tenants are protected from security deposit deductions for minor wear and tear. Could you please define what minor wear and tear is exactly? The reason I ask is my cat tore some small holes in the screen door, smaller than my thumb in diameter, and I'm paranoid I could be charged for them. Thank you.
So if it's like animal damage, yeah. Yeah, thanks. Good, Rob. I'm glad you have a helpful, positive presentation. um, uh, uh, Yeah, I think animal damage to a screen door probably is not wear and tear. Wear and tear is sort of like, oh, there's some like nicks in the paint and some wear in the carpet or something like that. But if like your pet has like caused little holes in the screen, I mean, you could always kind of throw on one of those little patches and hope for the best. But I do think they could probably charge you for that. The good news is that screens don't cost a lot to replace. So I don't see that being like a huge deduction from your security deposit. But I think the chances are, if that's what you're talking about, it counts, unfortunately. Sorry.
The other thing that I would add as someone who's rented for a lot of my life, um, when you start at a place, take pictures of your place when you move in, to help show the difference. I had someone try to charge me for something that was there when I was there, so when I got there, and I was like, I have a picture. So, anyhow, okay, next question. When there are roommates sharing rent for full house and only one of them has their name on the lease, are there any rights for the roommate not listed on the lease? And that was from Elizabeth.
That's an interesting question. For a while there were sort of not any ways for someone who wasn't listed to intervene in the case, even though they would also be impacted by the eviction judgment. But a rule recently was changed in Pennsylvania to allow tenants to, or to allow someone who's not on the lease to intervene in an eviction case, and be like sort of added as a defendant to the case so that they can participate in it and testify because it's going to apply to them. So there's a way to go about that. It's like a process. But the problem with that is that you don't want your name necessarily showing up on an eviction action because there's nothing right now in Pennsylvania, and there is positive movement on this. There's nothing that seals or hides eviction actions against tenants. Even if you win the case, even if you did nothing wrong, and it is simply the filing of the action that flags you for future landlords, and there's no way to hide that. So I think you need to think about whether you want your name associated with an eviction because it makes it harder to find a new place to live. But there is movement on an eviction ceiling bill in Pennsylvania that has bipartisan support, and so we're hoping for something like that in the near future. So you can do it, but you might not want to, is my answer.
Okay, great. Let's see. Yep, I think that that is all the questions. So thank you so much, Sarah.